Case summary. Partridge v. Crittenden, 1968, 1 WLR 1204 is a seminal English contract law case that addresses the distinction between an invitation to treat and an offer. The court ultimately held that an advertisement in a periodical is an invitation to treat, not an offer to sell, which means that it does not create a binding obligation to sell upon the response by a potential buyer. Background facts. Claimant, Mr. Partridge. Defendant, Mr. Crittenden. Mr. Partridge placed an advertisement in a magazine called Cage and Aviary Birds, which stated, "Bramblefinch cocks, Bramblefinch hens, 25s each." Mr. Crittenden responded to the advertisement, expecting to buy the birds at the advertised price. However, Mr. Partridge did not fulfill the transaction, leading Mr. Crittenden to bring a case against him. Argument. Claimant's argument. Mr. Crittenden argued that the advertisement constituted an offer, and by responding to it, he accepted the offer, thus forming a binding contract which Mr. Partridge was obliged to fulfill. Defendant's argument. Mr. Partridge contended that the advertisement was not an offer but an invitation to treat, meaning that it was merely an invitation for potential buyers to make offers to purchase. As such, no binding contract was formed by simply responding to the advertisement. Final outcome and legal justification. Outcome. The court ruled in favor of Mr. Partridge. It was decided that the advertisement was an invitation to treat and not an offer. Therefore, no binding contract was formed when Mr. Crittenden responded to the advertisement. Law justification. 1. Invitation to treat. The court relied on established legal principles distinguishing an invitation to treat from an offer. An invitation to treat is a preliminary communication which merely invites others to make offers, which can then be accepted or rejected by the party that made the invitation. 2. Precedents. The court referenced previous cases such as Fisher v. Bell, 1961, and Pharmaceutical Society of Great Britain v. Boots Cash Chemists Southern Lid, 1953, which reinforced the notion that advertisements and items displayed for sale are generally invitations to treat, not offers. 3. Reasoning. If advertisements were considered offers, it would place an undue burden on advertisers, potentially binding them to an unlimited number of contracts they could not fulfill. This would be impractical and contrary to commercial practices. Key concept. Implication. The ruling in Partridge v. Crittenden highlights the importance of distinguishing between an invitation to treat and an offer in contract law. This distinction is crucial for understanding when a binding contract is formed. Key takeaways. 1. Advertisements are generally considered invitations to treat unless they explicitly state otherwise. 2. An invitation to treat invites others to make offers, which can then be accepted or rejected. 3. The ruling helps prevent the impractical situation of advertisers being bound to unlimited contractual obligations. Understanding this case helps in comprehending the foundational principles of contract formation and the practical implications of advertising in commerce.